Section 286.011 Florida statutes. Meetings of public boards or commissions must be open to the public. Reasonable notice of such meetings must be given. Minutes of the meetings must be taken and promptly recorded. The complete text of the government in the Sunshine Law and related statutes can be found in Appendix B of your manual. It's important to remember that a constitutional right of access to meetings of collegial public bodies is also recognized in Article 1, Section 24, Florida Constitution. As articulated in Frankenmuth Mutual Insurance Company versus Magaha, 769 Southern 2nd, 1012-1021, Florida 2000, the Sunshine Law is of both constitutional and statutory dimension. Almost all collegial public bodies are covered by this constitutional mandate, with the notable exceptions of the judiciary and the state legislature, which has its own constitutional provision requiring access. Any exceptions to this constitutional right must be established by law or by the Constitution itself. The full text of Article 1, Section 24, Florida Constitution, is in Appendix A of this manual. The Sunshine Law specifically applies to any board or commission of any state agency or authority, or of any agency or authority of any county, municipal corporation, or political subdivision. This means it covers public collegial bodies across state and local levels as established in City of Miami Beach versus Burns, 245 Southern 2nd, 38 Florida 1971. The Florida Supreme Court in Sarasota Citizens for Responsible Government versus City of Sarasota, 48 Southern 3rd, 755-762, Florida 2010, affirmed that all governmental entities in Florida are subject to the requirements of the Sunshine Law unless specifically exempted. This sentiment was echoed in Florida Citizens Alliance, Incorporated versus School Board of Collier County, 328 Southern 3rd, 22, Florida 2nd District Court of Appeal, 2021. The law applies equally to elected and appointed boards or commissions, as noted in Attorney General Opinion 73-223. This includes special district boards, as per Attorney General Opinion 74-169, and boards created by interlocal agreement, as per Attorney General Opinion 84-16. Informal Opinion 2 Martelli, July 20th, 2009, also clarifies that the State Fair Authority, a public corporation created by statute, is subject to the Sunshine Law. It's crucial to understand that a legislative requirement for certain board meetings to be open does not imply that the board can meet privately to discuss other matters, as seen in Turner versus Wainwright, 379 Southern 2nd, 148 Florida 1st District Court of Appeal, 1980, affirmed and remanded 389 Southern 2nd, 1181, Florida, 1980. Segment 2, what entities are covered? Advisory boards. Now let's delve into advisory boards. Starting on page 1, advisory boards and committees created by public agencies can be subject to the Sunshine Law, even if their recommendations aren't binding. The deciding factor, as outlined in Sarasota Citizens for Responsible Government versus City of Sarasota, 48 Southern 3rd, 755-762, Florida 2010, is whether the committee has been delegated decision-making authority as opposed to merely information gathering or fact-finding authority. If decision-making authority is delegated, the committee's meetings must be open to public scrutiny regardless of how the parent governmental body reviews the recommendations. This was reiterated in Florida Citizens Alliance, Incorporated versus School Board of Collier County, 328 Southern 3rd, 22, Florida 2nd District Court of Appeal, 2021, which found that textbook evaluation committees with recommendation authority were subject to the Sunshine Law. Attorney General Opinion 23-04 further clarifies that the power to make recommendations can qualify as decision-making authority even if the delegating entity retains the power to reject. For instance, in Town of Palm Beach versus Gradison, 296 Southern 2nd, 473, Florida 1974, a citizen planning committee formed to revise zoning ordinances was subject to the Sunshine Law because it functioned as an alter ego of the city council in making tentative decisions. The Gradison court stated, any committee established by the town council to act in any type of advisory capacity would be subject to the provisions of the government in the Sunshine Law. Similar conclusions were reached in Spillis, Candela and Partners, Incorporated versus Centrust Savings Bank, 535 Southern 2nd, 694, 695, Florida 3rd District Court of Appeal, 1988, concerning a committee whose report was perfunctorily accepted by a board, and Lyon versus Lake County, 765 Southern 2nd, 785, Florida 5th District Court of Appeal, 2000, regarding a site plan review committee, Attorney General Opinion 98-13, and Attorney General Opinion 01-84, concerning a citizen advisory committee and a school advisory council, respectively, also support this view. The Sunshine Law does not apply a lesser standard to advisory committee members. They are equally bound by its requirements, as confirmed in Monroe County versus Pigeon Key Historical Park, Incorporated, 647 Southern 2nd, 857, 869, Florida 3rd District Court of Appeal, 1994. Informal opinion to Wallace, January 7, 2019, further stresses that an advisory group's functions, not how its members are appointed or their volunteer status, determine the Sunshine Law's applicability. Let's look at advisory boards appointed by a single public official on page 2. The Sunshine Law applies to these committees just as it does to those appointed by collegial boards. Informal opinion to Wallace, January 7, 2019, states that advisory groups appointed by a single public official are not immunized from the public meetings requirement. A significant case on this is Wood versus Marston, 442 Southern 2nd, 934, Florida, 1983. The Florida Supreme Court ruled that the Sunshine Law applied to an ad hoc advisory committee appointed by a university president to screen law school dean applications. The committee's function of deciding which applicants to reject was deemed a policy-based decision-making function. Other cases, including Silver Express Company versus District Board of Lower Tribunal Trustees, 691 Southern 2nd, 1099, Florida 3rd District Court of Appeal, 1997, Committee Ranking Contract Proposals, Florida Citizens Alliance Incorporated versus School Board of Collier County, 328 Southern 3rd, 22, Florida 2nd District Court of Appeal, 2021, textbook committees, and Linares versus District School Board of Pasco County, number 17-00230, Florida 6th Circuit Court, January 10th, 2018, Committee Developing School Attendance Boundaries, have reached similar conclusions. Attorney General Opinion 05-05, 85-76, 87-42, and Informal Opinion to Lamar, August 2nd, 1993, further illustrate this application to committees appointed by mayors and for transition teams. Next, we address fact-finding committees, found on page 3. A limited exception exists for advisory committees established solely for fact-finding. As stated in Sarasota Citizens for Responsible Government versus City of Sarasota, 48 Southern 3rd, 755, 762, Florida 2010, a committee is not subject to the Sunshine Law if its authority is limited to information gathering and it only conducts such activities. This is supported by National Council on Compensation Insurance versus Fee, 219 Southern 3rd, 172, Florida 1st District Court of Appeal, 2017, and Cape Publications Incorporated versus City of Palm Bay, 473 Southern 2nd, 222, Florida 5th District Court of Appeal, 1985. Attorney General Opinion 95-06 also confirms that a group functioning solely as a fact finder with no decision-making authority does not create a board or commission subject to the Sunshine Law. However, the actual function of the committee must be scrutinized to determine if it's exercising part of the decision-making process by sorting through options and making recommendations, as noted in Informal Opinion to Randolph, June 10, 2010. If an advisory committee has a decision-making function in addition to fact-finding, the Sunshine Law applies. This was clarified in Wood v. Marston, 442 Southern 2nd, 934, 938, Florida, 1983, which found a search and screen committee subject to the Sunshine Law because its screening function involved deciding which applicants to reject. Attorney General Opinion 94-21 regarding negotiating teams, and Collier County Public Schools versus Mason Classical Academy, 342 Southern 3rd, 753, Florida 2nd District Court of Appeal, 2022, which found discussions between school district employees and an attorney as part of a fact-finding investigation were not Sunshine Law meetings because no board members or decision-making committees were involved. Also provide context. The determination hinges on the committee's duties. Informal Opinion to Wallace, January 7, 2019, cautions that merely designating a committee's function as providing feedback isn't dispositive. The exact nature of the feedback is key. Attorney General Opinion 98-13 further discusses the application to community advisory committees. It is critical to note that the fact-finding exception applies only to advisory committees, not to boards with ultimate decision-making governmental authority. Finch versus Seminole County School Board, 995 Southern 2nd, 1068, 1071 to 1072, Florida, 5th District Court of Appeal, 2008, held that a school board conducting a bus tour to gather facts still had to comply with the Sunshine Law as the ultimate decision-making body. Informal Opinion to Sugarman, August 5, 2015, echoes this for pension boards. Moving to staff committees, on page 4, the Sunshine Law typically does not apply to staff committees or meetings. This is supported by Occidental Chemical Company versus Mayo, 351 Southern 2nd, 336, Florida, 1977. Disapproved in part on other grounds. Citizens versus Beard, 613 Southern 2nd, 403, Florida, 1992. School Board of Duval County versus Florida Publishing Company, 670 Southern 2nd, 99, 101, Florida 1st District Court of Appeal, 1996, and Attorney General Opinion 89-39, as stated in Knox versus District School Board of Brevard, 821 Southern 2nd, 311, 315, Florida 5th District Court of Appeal, 2002. The Sunshine Law does not apply when a governmental executive uses staff for a fact-finding and advisory function in fulfilling his or her duties. Therefore, a committee comprised solely of staff responsible for advising and informing the decision-maker through fact-finding consultations is generally not subject to the Sunshine Law. Bennett versus Warden, 333 Southern 2nd, 97, Florida 2nd District Court of Appeal, 1976, found that meetings of a committee advising on employee working conditions were not subject to the law. Attorney General Opinion 08-63 noted that while orientation sessions for special magistrates aren't subject to the Sunshine Law, allowing public attendance is good practice. Similarly, in Baker versus Florida, Department of Agriculture and Consumer Services, 937 Southern 2nd, 1161, Florida 4th District Court of Appeal, 2006, review denied, 954 Southern 2nd, 27, Florida, 2007. Communications among administrative staff for investigatory or advisory functions did not violate the Sunshine Law. Knox versus District School Board of Brevard Supra further clarified that a team interviewing and recommending applicants to a superintendent served only in a fact-finding or advisory capacity. Lyon versus Lake County, 765 Southern 2nd, 785, Florida 5th District Court of Appeal, 2000, also ruled that informal staff meetings were not subject to the Sunshine Law if discussions were merely informational, no decision-making authority was present, and no formal action was taken. Recent cases reinforce this. Florida Environmental Regulation Specialists, Incorporated versus Florida Department of Environmental Protection, 342 Southern 3rd, 710, Florida 1st District Court of Appeal, 2022, confirmed that staff meetings for contract management don't trigger open meetings requirements if there's no delegation of policymaking authority. Other examples include Molina versus City of Miami, 837 Southern 2nd, 462, 463, Florida 3rd District Court of Appeal, 2002, Police Firearms Committee not subject to Sunshine Law as purely advisory, JY versus Department of Children and Families, 922 Southern 2nd, 405, Florida 4th District Court of Appeal, 2006, permanency staffing meetings not applicable, and National Council on Compensation Insurance versus Fee, 219 Southern 3rd, 172, 179, Florida 1st District Court of Appeal, 2017, meetings for information gathering only. However, if a staff committee is delegated decision-making authority beyond mere fact-finding, the Sunshine Law does apply as established in Wood versus Marston, 442 Southern 2nd, 934, 938, Florida 1983. The determining factor is the nature of the act performed, not the committee's makeup or its proximity to the final decision. News Press Publishing Company, Incorporated versus Carlson, 410 Southern 2nd, 546, 548, Florida 2nd District Court of Appeal, 1982, found it ludicrous to exempt staff committees from the Sunshine Law if they perform decision-making functions. Evergreen, the Tree Treasurers of Charlotte County, Incorporated versus Charlotte County Board of County Commissioners, 810 Southern 2nd, 526, 531 to 532, Florida 2nd District Court of Appeal, 2002, emphasized that staff members' delegated decision-making authority stand in the shoes of such public officials for Sunshine Law purposes. Illustrative cases include Silver Express Company versus District Board of Lower Tribunal Trustees, 691 Southern 2nd, 1099, Florida 3rd District Court of Appeal, 1997, committee ranking, contract proposals subject to Sunshine Law, Roscoe versus Abro, number 03-California-1, 833, Florida 2nd Circuit Court, August 6, 2004, Committee Screening Parkway Expansion Corridors, Attorney General Opinion 05-06, City Development Review Committee, and Attorney General Opinion 86-51, Land Selection Committee of Water Management District. The Silver Express decision was cited in Florida Citizens Alliance, Incorporated versus School Board of Collier County, 328 Southern 3rd, 22 Florida, 2nd District Court of Appeal, 2021, which held that textbook committees with a quantitative rubric for evaluation were subject to the Sunshine Law because their selections clearly helped to crystallize the decision to be made by the school board. Similarly, in Daskett versus Palm Beach County, 877 Southern 2nd 8, Florida 4th District Court of Appeal, 2004, a pre-termination show conference panel was held subject to the Sunshine Law, even though the county administrator had sole disciplinary authority because that authority was delegated to the panel. In contrast, Sarasota Citizens for Responsible Government versus City of Sarasota, 48 Southern 3rd, 755, 763, Florida 2010, found no Sunshine Law violation when a county administrator discussed a memorandum of understanding with staff and consultants, as the team only served an informational role and did not make joint decisions. McDougall versus Culver, 3 Southern 3rd, 391, Florida 2nd District Court of Appeal, 2009, and Jordan versus Jenne, 938 Southern 2nd, 556. Florida 4th District Court of Appeal, 2006, also supported this distinction. Segment 3. What entities are covered? Candidates, commissions, ex officio board members. Let's move on to candidates or members-elect on page 6. The Sunshine Law does not apply to candidates for office unless the candidate is an incumbent seeking re-election. This is outlined in Attorney General Opinion 92-05. However, the requirements of the Sunshine Law do apply to members-elect. Section 2, 186.011, subsection 1, Florida statutes, extends the law to meetings with or attended by any person elected to such board or commission but who has not yet taken office. Thus, members-elect are subject to the Sunshine Law in the same manner as currently serving board members. This principle was established in Hoff versus Stembridge, 278 Southern 2nd, 288, 289, Florida 3rd District Court of Appeal, 1973, which stated that an individual, upon election, loses his or her status as a private individual and acquires a position more akin to that of a public trustee. Informal opinion to Lamar, August 2, 1993, confirms this for transition teams. A candidate who is unopposed is not considered a member-elect subject to the Sunshine Law until the election has been held. Attorney General Opinion 98-60, an informal opinion, DePopowitz, August 12, 2016, addressed this. Next, we look at commissions created by the Florida Constitution, also on page 6. Boards or commissions whose constitutional powers are explicitly prescribed by the Florida Constitution are generally not subject to Section 286.011, Florida statutes, when performing those constitutionally prescribed duties. This was affirmed in Canner v. Frumkes, 353 Southern 2nd, 196 Florida 3rd District Court of Appeal, 1977, regarding judicial nominating commissions. In re-advisory opinion of the governor, 334 Southern 2nd, 561 Florida, 1976, clarified that clemency power, being constitutionally prescribed, is not subject to legislative intervention. Attorney General Opinion 77-65 also found Chapter 120 Florida statutes inapplicable to the Constitution Revision Commission. However, a critical distinction arises when a commission's creation is authorized by the Constitution, but its duties are established by law. In such cases, the commission is subject to the Sunshine Law. Turner v. Wainwright, 379 Southern 2nd, 148 Florida 1st District Court of Appeal, 1980, affirmed and remanded 389 Southern 2nd, 1181, Florida, 1980, held that the Parole Commission, now known as the Florida Commission on Offender Review, created by law, is subject to Section 286.011 Florida statutes. It's important to remember that Article 1, Section 24, Florida Constitution, establishes a constitutional right of access to meetings of any collegial public body of the executive branch of state government, requiring such meetings to be open and noticed unless specifically exempted by the legislature or closed by the Constitution. Finally, let's consider ex officio board members, also on page 6. An ex officio board member is subject to the Sunshine Law, regardless of whether they serve in a voting or non-voting capacity. Attorney General Opinion 05-18 confirms this. Informal opinion to Ardham, June 24, 2021, specifically states that a mayor serving as a non-voting ex officio member of municipal boards is subject to the Sunshine Law. Lenarse v. District School Board of Pasco County, number 17-00230, Florida 6th Circuit Court, January 10, 2018, further reinforced that the Sunshine Law applies equally to all advisory committee members, even non-voting staff. This concludes our in-depth look at the scope of the Sunshine Law and the various entities it covers, from advisory boards to constitutional commissions and ex officio members. Thanks for listening. Until next time, remember, the truth dies in the dark, so let's leave the light on.